Good day. This is my labor case report. GR number 191825, October 5, 2016, DJ's Inn and Cafe and or Melinda Ferraris petitioners versus Maria Lorena Rañeses, respondent. Decision. Before this court is a petition for review on certiorari under Rule 45 of the Revised Rules of Court filed by petitioners DJ's Inn and Cafe or DGIC and Melinda Ferraris assailing the following. Decision dated April 29, 2009 of the Court of Appeals in which set aside the resolutions dated August 30, 2006 and November 30, 2006 of the National Labor Relations Commission or the NLRC and ordered the remand of the case to the labor arbiter for the computation of the monetary claims due respondent Maria Lorena Rañeses, who was declared to have been illegally dismissed by petitioners, and resolution dated February 8, 2010 of the Appellate Court in the same case which denied the motion for reconsideration of petitioners and the motion for partial reconsideration of respondent. Factual antecedents. Petitioners further claimed that it was respondent herself who requested that the SSS contributions not be deducted from her salary because it would only diminish her take-home pay. Thus, respondent received from petitioners the amount of SSS contributions, which the undertaking that she would comply with the law by paying the SSS premiums herself as self-employed. Respondent recorded her weekly wages and payment of SSS premiums in a notebook, which had since been missing. So yung respondent, nire-request niya na yung SSS niya ay hindi mababawasan yung kanyang sahod, which is claim naman nung petitioners. The labor arbiter decreed, premises laid, judgment is hereby rendered dismissing the complaint in the instant case for lack of cause of action and for not being impressed with merit. Yung case ay dinismiss dahil yung petitioner ay hindi masyado naasikaso at kulang sila sa ebidensya. Petitioners are hereby ordered jointly and severally to pay respondent the amount of 500 pesos, representing 13-month pay differential. Respondent and Muñin timely filed their respective appeals before the NLRC. Their appeals were eventually consolidated. The labor arbiter did not give much credence to respondents' charge of illegal dismissal because there was no positive or unequivocal act on the part of petitioners to support the assertion that respondent was dismissed. The NLRC reasoned, we uphold the findings of the labor arbiter. The records do not reveal of any written document to show that respondent and Muñin were indeed dismissed. On the other hand, petitioners vehemently denied having dismissed them, their verbal claims supported by self-serving and biased statements of two witnesses, namely Mercy Boraay and Mia Tormon, did not substantially prove their case. Thus, we find more expressive of truth and verbal declaration of petitioners supported by a sworn statement of one witness, Eva Gorospe, that after respondent and Muñin were reprimanded, made to explain and produce the 400 pesos shortage of their daily collection, they voluntarily ceased to report to work anymore. No proof is placed on record by respondent and Muñin to prove their claim overtime and holiday work. Respondent and Muñin cannot also avail of entitlement of service incentive pay under Article 95 of the Labor Code who regularly employs more than 10 workers. So dito, walang ebidensya na si respondent at Muñin, wala silang ay patunay na na-claim nila yung overtime pay and holiday pay. However, we see no reason to disturb the award of 13-month pay. This is an admitted claim, and the respondent and Munyin must be entitled to the same. Therefore, the labor arbiter as well as the NLRC failed to appreciate that doubts shroud the evidence presented by both parties, and both tribunals appeared oblivious of the dictates of jurisprudence that such doubts should be resolved in favor of the worker, as was pronounced by Nicario v. NLRC et al. The labor arbiter as well as the NLRC, sinasabi na yung both sides na si petitioner at si respondent ay walang sapat na ebidensya o pruweba para patunayan yung mga sinasabi nila. Kaya nag-decision na yung si Nicario, it was a well-settled doctrine that if doubts exist between the evidence presented by the employer and the employee, the scales of justice must be tilted in the favor of the latter. The Court of Appeals erred when it considered abandonment of work generally understood in employee dismissal situations, despite the fact that Night Owl never raised it as a defense. Under this construct, abandonment is a defense available against the employee who alleges a dismissal. This burden, of course, proceeds from the general rule that places the burden on the employer to prove the validity of the dismissal. Wherefore, premises considered, the petition is granted. The decision dated April 29, 2009 and resolution dated February 8, 2010 set of the Court of Appeals is reversed and set aside. The resolution dated August 30, 2006 of the National Labor Relations Commission in NLRC Court of Appeal, affirming in toto the decision dated February 21, 2006 of the labor arbiter in reinstated with modification that petitioners D. Jays Inn and Cafe and Melinda Ferraris, for just and equitable reasons extant in this case, are additionally ordered to jointly and severally pay Respondent Maria Lorena P. Rañeses separation pay equivalent to 1 month salary for every year of service, computed up to the time she stopped working or until February 4, 2005. So ordered. So the case of these respondents and the petitioners was reversed and set aside because there are lack of actions and lack of merits, because they cannot prove what they are filing in the court. So the decision is reversed and set aside.